So over and above that, though, I think it is likely, and this is a point that the Tannehills, I think, are not explicitly focusing on at any rate, I think it is likely that the principles of justice underdetermine the shape of the law. That is to say, that the principles of justice are consistent with a number of different legal resolutions of particular kinds of social problems. So, as I've suggested already, my guess is that a range of property rules might well be compatible with the demands of justice. And if that's right, it will simply be a matter of convention and custom which ones prevail in a given area. Now, it's going to be a matter of convention and custom which ones in fact prevail in a given area. That's just a sociological statement, but I'm making the broader claim, a more fundamental claim, that that's perfectly consistent with justice, at least in principle. Now, clearly we can imagine some property rules which would clearly be unjust, which wouldn't serve a community well, wouldn't serve individuals well, and so forth. But a range of rules certainly will be compatible here. It's going to be a matter of active decision using whatever procedures it ordinarily employs, which ones a defense agency will follow. This recognition, by the way, I think highlights the two kinds of legal arrangements that we could expect to encounter in a stateless society. It's worth just stopping for a moment to note the distinction between the two. We can call these territorial and non-territorial legal arrangements. Now, there would be no territorial monopolies by definition. If you've got a territorial monopoly over lawmaking and law enforcement, then what you've got is a state. But it seems to me that there certainly might nonetheless be a general consensus in a particular geographic area underlying support for particular institutional arrangements. So if that were the case, people wouldn't be forced to accept or participate. Again, if they were, we'd have a state. But there might be significant nonviolent social sanctions for ignoring the rules I'm talking about. In any event, though, there might be widespread support in a given community for particular standards. And we might suspect that this would be more likely in a small, close-knit, relatively immobile community. Kevin Carson, following Larry Gambone, has talked about this as a matter of mutualizing community institutions. So the idea is that institutions formerly monopolistic, coercive, and tax supported become voluntary and funded by user fees or by charitable contributions. But we can imagine local institutions being mutualized in this way and acquiring or retaining a great deal of local support, so that the way those institutions operate, the particular norms that they follow, turn out to be ones that are widely endorsed. And in this case, we would have, in a particular geographic area, probably pretty consistent support for a given set of norms that are territorially based. So alternatively, though, we can imagine what I would call deterritorialized law. Now, this already happens in limited degree in places today like Israel, in which membership in a particular religious community determines the legal system to which one is subject. Now, in Israel, this is primarily true with respect to family law. In fact, I can't swear that it's true with respect to anything other than family law, but the idea is that issues about marriage and divorce are not decided courtesy of some general set of secular legal rules. Rather, people who live together in the same community are, in virtue of their membership in particular religious communities, subject to different rules about marriage and divorce. So, we might imagine a situation in which 4 defense agencies, let's say, operate in a given region. Now, each of them, in effect, has a territory, but understand that the territory of each defense agency just is the sum of the various properties that its members or clients ask it to protect. So we can say that it has a monopoly of force in this territory, but the territory is going to be a kind of patchwork quilt within a given geographic area, and anybody can, per the contractual arrangements that she or he has made with the defense agency, exit at any time. And so, of course, territory might shift, probably would shift on an ongoing basis from one defense agency to another. So 4 neighbors might, in theory, use the services of different defense agencies. And so, in theory, each one of these agencies might operate, each neighbor might operate within a framework governed by different legal standards. So here, an agency does not have anything like a dominant position in a given region, and so its legal system doesn't have a dominant position within a given region. Rather, different people in that region would operate under the umbrella of different legal norms. Now, I don't think there's anything to worry about here, of course. Clearly, legal systems can work when they do this kind of thing. Again, the Israeli example, while it creates some problems, certainly for people who really would rather not identify with any particular religious community. I'm not saying that this is a perfect model, but it certainly highlights the possibility of the coexistence in the same geographic space of different legal systems. But the same thing, of course, is true internationally. And we have choice of law rules and conflict of law rules that operate in today's world and enable disputes to be resolved. And this is true both when we think about international legal disputes of one kind or another, but also, of course, in the United States, and I'm quite sure this is paralleled elsewhere, where people who live in different regions of the United States may be subject to different laws. And so you can imagine a case in which a conflict arises in connection with, let's say, an auto accident that occurs in Wyoming that involves someone from Minnesota and someone else from Florida. We have ways of sorting that out. And the same kinds of rules that enable that sort of conflict to be sorted out could easily enough enable the resolution of conflicts of the kind I'm envisioning. Now, while there certainly will be variety in a stateless society's legal order, I think the Tannehills are right that people in a stateless society on the whole would confront far fewer, much simpler laws than people do at present. And an obvious reason for this is that there would be market pressures for standardization, both to the extent that people's similar circumstances prompted standardization across arbitration agencies and procedures, and also because one key difference between what happens today and what would happen in a stateless society is that legislators can externalize the costs that result when they create complex legal codes. They can externalize those costs on others. I mean, there may be some individual costs that they bear, but that isn't a major part of the issue. It would be much harder for defense agencies or communities with mutualized services to do this. Creating complex, difficult to administer laws would mean having complex, difficult to administer legal procedures, and it would certainly mean that people who didn't like those procedures, didn't like the complexity of those laws, would have good reason to seek alternatives. And in a situation in which there were no territorial monopolies, obviously people would be much more likely to do that. Now, states, as the Tannehills rightly emphasize, tend to create rules that aren't appropriately responsive to particular circumstances, and they have relatively little incentive to do that because of their political structure, right? States really can operate without a great deal of accountability and flexibility. Now, in a stateless society, this would not be the case, I think, for at least two reasons. So one, obviously, institutions would tend to be more small scale, and because of that, they would be more nimble and capable of being more responsive. And of course, people would have choices. So institutions that didn't respond flexibly and appropriately would be abandoned, I think, in favor of institutions that did respond flexibly and appropriately. Decentralized, diverse lawmaking institutions could craft what is now commonly called polycentric law. Now, to some extent, this is just a piece of jargon designed to conceal from unreflective readers the fact that we're talking about law without the state. Polycentric law is law that's not the product of a single definer or enforcer or decider. I think it's clear that polycentric law could meet people's needs much more effectively than law made by the state.